Hello, everyone. Andrew Reed here, and today we're going to talk about NCA exams versus PLTC versus articling. So, someone who's passed both the NCA exams and the British Columbia Bar Exam program, known as the PLTC, and as someone who's currently over halfway through his article term with less than 4 months to go, I am somewhat qualified to compare and contrast the three obstacles in the path of a foreign law graduate in becoming a lawyer in Canada. So, let's get started. I'm going to use three categories for comparison. Number one will be difficulty. So this is academic challenge, pure academic challenge. The second category will be stress. So this is a total amount of work and pressure. And the third category for comparison will be benefit to practice, which will be subjectively based on my articling practice, which has been for me a supervised practice of law, including giving legal opinions, drafting, file management, the works. So let's start with the first category, which is difficulty, academic challenge. So I think the NCA exams will be the winner here in this category of difficulty by a modest amount, because the NCA exams are the starting point, and in my case, because United States law is so randomly different and randomly similar compared to Canadian law, so the NCA exams required a huge leap of academia, especially in the subject of constitutional law, which I personally found the most difficult of the NCA exams. PLTC would be a close second in terms of difficulty because it requires true proficiency in practicing the law in at least 11 different subjects, and you have to master these within a 10-week period with only very limited overlap between NCA subjects like professional responsibility, criminal law, and then PLTC subjects. So articling, the third, can be challenging academically. It can, because you're often confronted with things you don't know, but if you're lucky, you'll get great mentors at your firm who can help point you in the right direction or help explain key concepts to you. And in PLTC, you may have much less time and brain capacity left for learning compared to the NCA exam. Everyone's experience is different, so I can only really speak to mine. But I would rank NCA as the most academically challenging of the three obstacles to practicing law in Canada. The second criteria will be stress, the total amount of work and pressure. So in this category, for me, PLTC was a clear winner. It was the most stressful by some margin. So the PLTC requires actual competency in subjects like advocacy, which requires you to argue in front of a judge, well being judged, and contracts, which requires the drafting of a contract from scratch. There's interviewing, and all this culminates in a two final exams that are multi-subject exams, very similar to the NCA exams, except you're covering a much wider range of topics, but in a very similar format. So the final exams are like taking 6 or 7 NCA exams at once in a 2-day period. However, the format of the questions is generally less about your analytical abilities, like the NCA was, even though that's still part of it, and more about your grasp of the material, and in some ways in your ability to find the material, because it can be buried way down in there. So PLTC wins in terms of stress. It's just so much to pack in within 10 weeks. Your brain becomes mush. You don't even know what day it is. But you have to know what day it is because you have assignments to do. You can't miss a single deadline. Articling, I would say, is a close second in terms of stress to the PLTC. So this is basically a real-life simulation of PLTC, just likely with many less subjects. But for me, there's just as much pressure because I'm dealing with real deadlines, real people and their problems. I'm doing long days, not always, but my longest day was 17 hours. So you have real people and their problems, long days, real consequences, and it can be quite stressful. Not just quite as concentrated in stress as the PLTC. So if you're in the right firm, you'll be well supported through your challenges. Well, articling, and you have some light leeway for reasonable mistakes. NCA, as stressful as it was, especially with waiting for results, is relatively easy as you can study 1 to 2 subjects at a time, so you can really narrow down your focus. And you can do it at your own pace and schedule, at least in the sense that you know when your exam is coming. And it's not crammed into a 10-week period like PLTC. So the final criteria, which we will discuss, is benefit to practice. So I think articling wins this one by a huge margin, in my humble opinion, because you directly learn with a tried and true methodology, hopefully, exactly what you need to learn to perform your job as a lawyer, all while being supervised and having people to ask about the things you don't know about. So PLTC ranks second in terms of benefit to practice, in my opinion, because it was especially useful to learn elements of things like family law, real estate law, collections, civil procedure law. Those things tie into the corporate and estates law that I was doing and that my area of the firm focuses on. And I'm pretty sure the opposite is true as well. I mean, you need to know all areas of the law to practice. And so getting these basic equivalencies, these basic fundamental components of all the areas of law, I think is very helpful. These things go outside the box always. The third, in terms of benefit to practice, was the NCA. So it's the lowest on the list because I have not had to do any pith and substance analysis in my 5 months of articling so far, not a single one. Some NCA material was helpful for the PLTC, especially indigenous law, a few other maybe professional responsibility, but not once has anything actually applied to actual practice from the NCA so far. It has come in handy, though, for the occasional riveting discussion amongst the lawyers in the firm, just relating to current issues or whatnot. It's helpful to have the basic knowledge that you would get at Canadian law school, so you can just hold your own in a conversation where they might be assessing the constitutionality of a new law. So at least in that sense, it was useful. So that is my comparison. I hope it helps. I hope it provides you with a bit of what you might expect for your own experiences in the provinces that are similar to British Columbia. I would really appreciate it if you'd leave a comment or at least a like, and I wish you the best of luck in your upcoming exams.